Today's topic is preponderance of the evidence, the middle ground standard of proof in the series on the 5 standards of proof most relevant to law enforcement. I'm Steve Serbalik, and I'm a panel attorney with ASCOPS in Arizona. As always, this is a topic summary and not legal advice. So if you have questions about your specific circumstance, make sure that you consult with a lawyer like me. To briefly review, the 5 standards of proof most relevant to officers in order from the lowest standard to the highest standard are reasonable suspicion, probable cause, preponderance of the evidence, reasonable likelihood of conviction, and beyond a reasonable doubt. Last week, I covered probable cause, the legal standard directly discussed in the 4th Amendment of the Constitution that, generally speaking, must be met to search someone and to place them under arrest. And today's topic, the next highest standard to consider, is preponderance of the evidence, which is met if a proposition is more likely to be true than not true, or the balance of probabilities. The concept of the preponderance of the evidence is key in most civil cases, in many family court matters, and in most circumstances involving affirmative defenses or mitigating circumstances. Preponderance of the evidence is also the only standard that exists in the law that can be actually quantified by a number. The common expression is that this standard is met by 50% plus 1. Or if you picture the scales of justice perfectly balanced, the preponderance of the evidence can change by adding a single feather. Additionally, in most administrative processes like internal affairs, in order for an officer to receive discipline, the investigation needs to establish that misconduct occurred by a preponderance of the evidence. Now, it's important to know that a he said, she said scenario where you have 2 witnesses that have contradicting stories does not always lead to a tie. Fact finders, judges, and investigators can consider credibility determinations or their impression of a witness's truthfulness to help them decide if a preponderance of the evidence is met either way. But if it's an exact tie, then the preponderance of the evidence standard has not been met. As discussed in last week's video, probable cause is considered a measurable standard, something that needs to be supported by significant facts, but probable cause is something lower than a preponderance of the evidence. And officers should also take note that for the purposes of civil liability, whether an action or instance of misconduct occurred only needs to be shown by a preponderance of the evidence. And, like the circumstances surrounding probable cause, as your investigation develops, the preponderance of the evidence can shift if you learn facts that tend to show that something that you once believed did not occur. Finally, remember that even if you meet the standard of preponderance of the evidence, without a solid case supported by admissible evidence, prosecutors still won't be able to convict anyone. Next week, I'll cover the reasonable likelihood of conviction standard, which is the standard used to determine if a prosecutor will move forward with the criminal charges suggested by an arresting or submitting officer. I'm Steve Serbalik. Thanks for watching, and stay safe out there. If you're interested in watching another relevant video, click up here. And if you'd like to subscribe to the channel, click down here and then hit the notification bell to receive messages when new videos are posted. Videos are posted every Sunday at 5:30 p.m. Arizona time.